We started litigating on digital rights when Nigeria passed the Cybercrime Prohibition Prevention Act. So there are still two offensive provisions of that act. Section 24 and Section 38 of the act. Section 24 says that whoever sends a grossly offensive message by electronic means has committed an offense and could either go to jail for 7 years or be fined for 10 million naira and above. So we found it very dangerous in the sense that the law does not define what grossly offensive means, and it has been given subjective interpretation, especially by the high and mighty in Nigeria. So if somebody writes anything on social media, somebody writes anything on WhatsApp group, somebody writes anything on Facebook, and the subject finds it offensive or grossly offensive, even if a reasonable man will not find it offensive, they have been using the machinery of the state to harass, to intimidate, and to incarcerate mostly bloggers and journalists, because they are the ones who always express themselves openly to, sometimes investigative journalism. And we've had cases where journalists have been taken up and they've been taken to court and they've been remanded. In some cases, they won't even be taken to court. They will just be remanded on the strength of that provision. So we went to that was as far back as 2016. And that was where my journey started in digital rights, actually. So we approached the Federal High Court in Nigeria for declarations that that provision is likely, and that's what our Constitution allows. The Constitution allows for anybody, any citizen, anyone to approach the court if you feel that your rights, your fundamental rights are likely to be violated, not even until it is violated, because you don't have to wait for it to be violated before you approach the court. So we approached the Federal High Court, yeah. We lost at the Federal High Court. The court said the law wasn't contrary to the Constitution, it wasn't a violation. We approached the Court of Appeal. We got support from some international organizations who sent us materials for us to do some comparative analysis of what happened, especially the case in Kenya. Kenya had this Information Technology Act, is it? And I think what Nigerian legislatures did was to copy and paste Kenya's Information Technology Act. And as at the time we were copying and pasting, Kenya had gone to court and Kenya had set aside the same legislation. So we were, so we were in the. So we told the court that the people we are copying, because it has now become the standard practice in Africa now for governments to copy themselves. Something happens here, another government picks it up. They just remove the name of the country and they put their own there and everything, hook, line, and sinker. And that was exactly what we did in Nigeria. And we told them that the people you have copied, they have corrected their mistakes. Can we also correct our own? But no. The Federal High Court didn't agree with us. The Court of Appeal agreed that yes, we did a fantastic job on the brief. But unfortunately, they did not agree with us. So we are at the Supreme Court right now. But while the matter is at the Supreme Court, we are taking it to the ECOWAS Court. We argued the matter at the ECOWAS Court last month or 2 months ago, and we're expecting judgment in June. So that was the beginning of my journey in digital rights. And we've had a couple of other matters that we filed in digital rights, and up to judgment stage, up to appeal stage. And so that's it. That's the most remarkable I can talk about right now.
So in Cameroon, do you experience the same type of environment as a blogger when you're writing or releasing articles? Maybe you or the members of your association.
First of all, I want to mention something specific to Cameroon. We have a fundamental law but we are using two different codes. Because as I said, we have the heritage of two systems, two judiciary systems, the common law for the Anglophone system and the civic law for the Francophone system. So, in terms of digital rights, it's something very new in Cameroon, which has to take care of all the two systems' specificities. Concretely, we have the first law coming by 2010, the law on cybercrime in Cameroon. But that law was not really specific, giving not some details about what is condemnable or not. We have a recent history on hate speech, ethnic and communities division these few years. That puts the government, allow the government to propose some articles and new laws about hate speech, outrage, insult against a specific community or against an ethnic group. You asked me if I experience some difficulties with the bloggers. Not at all. Not at all. Because our association is too new. We just have 2 years of legal existence because we were struggling since 10 years to have the right to have an association of bloggers in Cameroon. So when we had the act, the legalization of our association, we do a lot of advocacy. First of all, to train the bloggers in the means of ethics and deontology. Secondly, to make sure the government respect the freedom of speech of these bloggers. And thirdly, we mentioned that we should not go through the law. We don't have to stigmatize a specific community, as I said before. So the bloggers of our association are struggling to respect these rules.
And so you mentioned that in your advocacy, the second thing you mentioned was you want the government, you train to enhance the government to respect your freedom of speech. So are there instances in Cameroon where the government has done anything that has in such and sort infringed on your freedom of speech?
It's difficult to respond because who is blogger, who's not blogger? First of all, we have to define. All Cameroonian bloggers are not members of the association, first of all. There are some of them who are independent and they have their manner of thinking and they have their opinion. But unfortunately, we have certain cases where people use their status of bloggers to write fake news. And if you do so, you go through the law and you have to be condemned. It's the same case with journalists. It's not because you're a journalist or blogger that you are not involved to respect the law. You should respect the law. If you are lying, if you are saying something about an event which is not right, you have to respond to the court. But not because you are a journalist or because you are a blogger. It's just because you are not telling the truth. That is the law.
So, what happens in Nigeria if you lose your case? What happens? You're now in the Supreme Court, right?
Of course, every litigation lawyer, once you are preparing the processes, even if you are the devil's advocate, you know that there's the possibility of losing. So you cannot possibly say that every matter you file, you must win. So, and that's where we talk about strategic litigation. So sometimes, most of the cases, and that's the interesting part of public interest litigation, most of the cases we don't set out to win. Most of them we do not. We just want to either push policy change, enlighten the public, put the government on their toes. For example, I'll give you an instance. We have a data protection regulation in Nigeria. But before we add the regulation, we had been taking government agencies to court on the likelihood of violation of privacy. So Nigeria at some point wanted to enforce, or we're still trying to enforce anyways, that's what we call national identification number, just like the social security number in the US and them. So part of the cases we took to court was that you can't start enforcing, and the law requires you to use that number for every essential service. The banking, the insurance, the loans, the health services, everything. So we went to court and said, you know what? This, under the law, this your national identification number is likened to social security number. And we know the implication of that. We know the consequences of exposing your social security number to the public at will. Because the law says you put it on everything. It was even funny that they said we should also start putting it on court processes. So if a lawyer files a process on behalf of a party, I'm supposed to put my national identification number on it. But thankfully, the Supreme Court has ruled, Nigerian Supreme Court ruled that that particular law does not regulate court processes, so we don't always have to put it there. So we went to court and we said, come, you can't enforce this thing without having safeguards, without having adequacy level of protection. So we knew that some courts might struggle with it, but we just wanted we wanted to push the government to do something about it. All of a sudden, they came out with the NDPR, which is extremely useful now, although it has its own shortcomings, but it's useful. So, I mean, losing the case, the Supreme Court has not even given us a date yet, anyways. So we don't know when the Supreme Court is going to give us a date. The ECOWAS court, we also still want to use it to push the local court to see the reasons why they should think the way international courts think. Because if Kenya could have struck out the provision, India did the same thing. We cited an English decision where such laws were also struck out. And we wanted to use it to persuade our own courts to strike it out. But it is not really about winning or losing. It is more about sensitizing the public. It is more about pushing the government to see the use of this law, and also making the courts, in cases where the matters eventually get to court, getting the judges to see the use of the provision, and its application not to be subjective now to the complainant's whims and caprices.
Hearing you speak, I just reflected on what you had said before, in which African governments just copy from each other. Because you've reminded me that in Kenya, we as well have a digital identification system that we are already implement. Okay, we already have, but they are waiting legislation to implement. And so on the same note, they rolled out the digital identity system. Then the court told them you need adequate data protection. Then they passed a Data Protection Act, and they released regulations without a data protection commissioner who is supposed to ensure or oversee the implementation. So in this regard, it looks like African governments are copying from each other when it comes to legislation and implementing of activities. So what does that mean if we're copying, like for example, quote unquote bad laws? Like you said, we copied from Kenya, but they corrected it. So what is the effect of, like, the butterfly effect of copying things across board or across region?
So thankfully, Nigeria right now, when we discovered the use or the scourge of the Cybercrime Act and how it's been used to embarrass people, such that if you say anything on a closed WhatsApp group, you could be picked up, or people have been picked up. Yes, where someone expresses an opinion, a political opinion, against a politician in a closed WhatsApp group. The person has been picked up on the strength of Section 24. So the question we asked ourselves, so we're trying to fight the law. So what we have told ourselves in Nigeria now is that it is better to fight a bill than to fight a law. So once a bill gets to the legislature, we look at the content. Now we have two funny bills. We have the internet falsehood manipulation bill, which we call social media bill. Although we've gone to court to challenge it as well, we're in court against it. There is another one called communication tax bill. I think they are trying to copy what you guys have in Tanzania. Is it Tanzania where they have the social media tax?
Yes.
Uganda.
Uganda.
Oh, Uganda. So when I go for international conferences like this, I try to pick my friends. So when I discovered that Uganda had that social media tax, I stopped being their friends because I didn't want Nigerian government to copy. But it is late in the day now. So we've copied it, but we are challenging it in court already. And so what we now do in Nigeria is once the bill is in the legislature, we look at the content. We make our representations. Before then, we go to court. So we attack it from all angles. We attack it from the advocacy point. We attack it from the litigation point. And because we have a section in our constitution that says that even while at the bill stage, the court's jurisdiction to look at the activities of the legislature cannot be outlawed. The courts have jurisdiction to look at what the legislature is doing. Because if they do anything contrary to the constitution, it's going to affect everyone. So the court at that stage will have to look at the constitutionality of the activities of legislation. So basically, that's what we do. So our own strategy in Nigeria is, okay, once a bill is proposed, we look at it, we do advocacy against it, we enlighten the public so that everybody sees the ills or the possibility of damage the bill could cause when it becomes a law, and we try to tackle it from all angles. And for some extent, some have succeeded. I remember in 2017 when the Nigerian legislature was going to pass an NGO regulatory bill. The bill was going to regulate NGOs. In fact, the strategy for them was to deregister all NGOs in one swell, just at once. One fell swoop. That was what they wanted to do with that bill. If the bill had been allowed to be passed into law, then most NGOs would not exist because you would have to go back to the government to register, and the license they give you will just be 1 year, which is renewable. We attacked it from all angles. We went to court. I filed a matter in court, and I remember some other like 25 or 50 NGOs also filed a matter in court, and some NGOs were doing a whole lot of advocacy against it, and the bill eventually died with the last one. Okay, thank you.
Okay, so as we prepare to wind up, we've heard what they're doing in Nigeria. So in Cameroon, you said you have civil and a common law system. So just for the audience, because we are a common law country, I understand that in civil law countries, so the Kenyan constitution allows a person to bring a suit in public interest. So like he's saying, I can do public interest litigation and just go to court if I think this is bad law. But in Cameroon, in civil law systems, I actually have to have locus to bring the case to court. So in Cameroon, you have to challenge the bill before it becomes law. After it becomes law, I have to now have locus to challenge the law. So as part of any strategic litigation, or as part of trying to come up with, if let's say, for example, the Cameroon legislation or the legislature in Cameroon decides to come up with a law, with bad laws like they're doing in Nigeria or Kenya, how would you as a Bloggers Association of Cameroon or ABC respond to that kind of law after now it's become the law?
Thank you. We are struggling to be a task force. First of all, as I told you, we made 10 years to be recognized.
Yeah.
So this is our first victory.
Yeah.
Secondly, you should work with lawyers, NGOs, and other partners to train the bloggers, because bloggers are coming from many areas. So I'm not sure they are aware on social issues, social media issue, and laws issue in general. So the next step is to do a lot of training and advocacy towards the bloggers. And because our government is, I want to say, is responding more quickly than us. So we should look forward, I think, in the few years, we propose some specific ideas and proposition to our government to change bad laws. I thought because
Okay.
they were as
As a final remark, as a lawyer, and he's mentioned some of the things they can do. They will engage lawyers to train people to do all these things. And would you just explain to us the opportunities lawyers would have when they're trying to do public interest litigation? Like bearing in mind we're doing it, like as you said, to change bad law, and it has cost implications. So, what is your advice?
First, lawyers should be passionate about public interest litigation. So if they're not passionate about it, it's difficult because some unpassionate, so to speak, would always look for the financial gains to get from it. But if we keep looking at that, then we might not get anywhere. Basically, it is just for the purpose of changing our laws, letting our laws get better, and like he said, strategic litigation, working with the NGOs, working with stakeholders, and we can always get better if you do that. Yeah.
Okay. Thank you so much.
Thank you very much.